So, um, good evening, good morning, and good day. Thank you so much once again for choosing to spend a little bit of your time with me. I do apologise for everything. Um, anyway, welcome. Uh, the dissociated Sergio Costa court stuff is over, or not actually over. A part of it is over, and we're going to be having a look at the court documents, and I shall be trying to give my best idiot's analysis. Try to break down and explain some of the things that will be happening. Speak like Jacob Rees-Mogg. Fuck off.
Never take your own life. Listen, five Red Mac. Never take your own life.
Woo! Thank you, Tay. So, I've already gone through this document and been making notes or highlighting sections that I think are of particular relevance and key interest. But before we have a look at that, it would be useful for me to just quickly clarify some of my own feelings, because those who know my content, majority of the people that know my content, are aware of the fact that me and Dissociated haven't exactly gone on throughout the years. We've never ever actually directly interacted with one another either. I've made some videos about them critiquing the content, and they've spoken about me in a podcast or two, but we've never directly interacted with each other, other of course than them channel striking me 3 times and 4 times. It's been years now. Anyway, because of this stuff, you might think I'm coming into this with a very negative angle towards them, and to be perfectly honest, at the outset, I probably was. I definitely was. But I am somebody who cares about justice. I'm somebody who cares about right and wrong more than anything else. And the reality is, the more that we found out about this whole situation, Sergio's actions towards Dissociated, their simple, gross, misogynistic, lecherous behaviour, and other various key aspects of the story, the more I couldn't help but see this as simply being a story about a wealthy, powerful man being rejected by a woman half his age and using his wealth to destroy that young woman's livelihood and career, and try to bury them under litigation and lawsuits. Story as old as time. And I also saw at the same time something unfolding that could affect not just Dissociated and those close to them, but every British YouTuber. All of us. As a whole. The reasons being that if Sergio could win this, if Sergio won this, it would mean people could legally claim others' work here in the UK for 1 or 2 sentences in a video. And that was scary precedent that was about to be set. And I was scared. I genuinely thought, I will be fully honest here, I've been saying this for months now, I genuinely thought that Dissociated was going to lose. I didn't think there was a chance in hell that they could win. I really didn't. Because of how this shit works here in the UK in general, because of the various power imbalances at play here in the UK, I did not think she had a fucking chance in hell whatsoever. And it's very promising for women in the UK as a whole, for all content creators in the UK as a whole. This is so. I guess I should say, in my opinion, and the judge's opinion, Dissociated has won this fairly flatly. Sergio is arguing otherwise, but Dissociated has won this hands down. And let's have a look at it, and I'll explain why. Fuck litigation abuse. I don't care how bad of a person she is. No female or woman deserves to be harassed and abused by a man because abuse and harassment isn't a punishment. Yeah, no person at all deserves the treatment that they've undergone whatsoever. But there is a particularly predatory nature to all of it that the judge remarks upon. Get ready for, honestly, some of the best legal burning I have seen in a document in some time. First, before we get to the more enjoyable stuff, we do need to speed ourselves through the initial bits. So, Costa v. Associated Limited, the introduction. In about March 2018, the second defendant, Miss Wilkinson, set up a YouTube channel under the name Dissociated. Miss Wilkinson is affected by a condition known as DID, formerly called multiple personality disorder. DID is characterized by an individual taking on two or more alternate and distinct personality states, which Miss Wilkinson referred to as alters. Miss Wilkinson uploaded videos about DID and herself onto the channel, raising awareness and providing help and support to others with the same condition. The channel became successful, and by May 2021, it had over 1 million subscribers. From August 2018, Miss Wilkinson began to monetize the channel. In 2019, gross earnings were over £57,000, and in 2020, nearly £105,000, which is basically dead on what I predicted originally. The first defendant was set up by Miss Wilkinson as a corporate vehicle for running her business and operated as such from August 2020. You should be happy. I'm happy about all this, honestly. In March 2020, the claimant, Mr. Costa, emailed Miss Wilkinson for the first time, making comments and suggestions about the Dissociated channel. Mr. Costa is not affected by DID, but said he wished to support Miss Wilkinson's project. For 3 months or so, Miss Wilkinson kept a cautious distance, but then they began to work together to some degree. Miss Wilkinson is based in England, Mr. Costa in Portugal, so the cooperation was remote. 9 literary works later emerged. It is common ground that of these, 8 are works of joint authorship, the joint works. The 9th, referred to as the disclaimer, involved some input from Mr. Costa, but it is Miss Wilkinson's case that his contribution was too insubstantial to have made him a joint author. There was a falling out in early November 2020. At this point, Mr. Costa took issue with the channel's continued use of the joint works and the disclaimer. He submitted takedown notices to YouTube, which led to videos being removed from the Dissociated channel. Subsistence of copyright in the joint works and the disclaimer is not in dispute. Mr. Costa claims an injunction to restrain the defendants from infringing the copyright in the joint works and disclaimer, together with damages or an account and related relief. Miss Wilkinson's case is that on 16th of June 2020, a contract was formed between her and Mr. Costa. This was before the joint works and the disclaimer had been created. Miss Wilkinson says that the agreement contained implied terms, according to which Mr. Costa granted to her and to her successors and assignees a perpetual, irrevocable license to use any works created by the two of them on Miss Wilkinson's YouTube channel. There is also a pleaded defence that Mr. Costa effected an equitable assignment of the joint works to Miss Wilkinson, but that was not pursued. Miss Wilkinson's counterclaim is that Mr. Costa's submission of takedown notices to YouTube was in breach of the contract and also constituted unlawful interference in Miss Wilkinson's business. Mr. Costa accepts that he granted the defendants a bare license to use the joint works and the disclaimer, but says that the license was terminated by him in November 2020. He contends that there was no contract and his submission of takedown notices did not in law constitute unlawful interference with Miss Wilkinson's business. So, that we understand all of that. The TLDR is, well, they give us a TLDR. The issues. Whether the disclaimer was a work of joint authorship, So the disclaimer being the disclaimer in the information box. Whether a binding contract was concluded on 16th of June 2020. If there is a contract, whether it contains the implied terms alleged by Miss Wilkinson. When the bare license granted by Mr. Costa to the defendants to use the disclaimer in joint works was terminated. And whether Mr. Costa's instructions to YouTube to take down videos were an act of unlawful interference. Whether such instructions were in breach of the contract. And if the answer to either 5 or 6 is yes, the quantum of loss suffered by the defendants. Okay. So these are the ultimate 7 contested issues. Okay. I just found this bit where the judge discusses hearing evidence from both witnesses. They remark Miss Wilkinson found the stress of giving evidence difficult and was given a break at one point. I remember a lot of people being like, oh, are they going to take a break? Yeah, they actually did. But she recovered her composure. I commend Mr. Eldridge for his conduct of Miss Wilkinson's cross-examination, which was courteous and considerate. Also interesting to note, thanks to the initial DID claim, the judge was obviously keeping an eye on the prosecution's cross-examination, making sure it was all right. Very interesting. All right, then we get some background. We've looked at all this background a lot in the past. Nothing here is particularly new. Until we get to this bit's just funny to me. Mr. Costa said that after observing that Miss Wilkinson was receiving criticism online for describing herself as a professional, and the Channel A mental health education service, even though she was not professionally qualified, he looked into the manner in which similar channels describe themselves. He took the view that the channel should stop using the term professional and should clarify the limitations on the advice given. In WhatsApp exchanges on 6th August 2020, Mr. Costa shared his view with Miss Wilkinson. She drafted a disclaimer. Mr. Costa pleaded case is. Associated wrote the first draft of the disclaimer. Claimant added a sentence and made some other minor edits. The WhatsApp transcript indicates that Miss Wilkinson showed her first draft to Mr. Costa. The following extract begins with that first draft. Chloe wrote the disclaimer. Despite Mr. Costa's pleaded claim, there was no documentary evidence of further minor edits by him. This is the work relied on, and with Mr. Costa's contribution in italics, blah, 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 blah. So you can see here, this is Mr. Costa's contribution. That's the rest of the disclaimer. Doesn't count as joint authorship. As we'll get to. Sorry, spoilers. Spoilers! Spoilers. This I found very noticeable. Mr. Costa was granted manager access to the channel in October 2020. He said he was shocked to find out that Miss Wilkinson was making money from the channel, and presumably how much. He felt she had lied to him and others about it, and said that he became concerned that therefore she would use his work for unethical purposes. He added that he was worried about Miss Wilkinson's mental health. We know that's just a load of absolute bullshit. He is slimy. So here we get to whether the disclaimer was a work of joint authorship. And there's a whole load of the law and precedent setting and explaining the whole process. And then slimy, egotistical rat kit, idiot and obscene. Sergio. Give me an S. Give me an E. Give me a... Savage. The WhatsApp transcript suggests that it was Miss Wilkinson who first proposed using a disclaimer. It may be that Mr. Costa had also thought of it, but when Miss Wilkinson created the first draft, I think that she was acting solely on her own idea. Mr. Costa's emails of 20th of April and 16th of June 2020 indicate that the role he was offering was one of friend and critic, not a collaborator within the meaning of Section 10 of the 1988 Act, Act 1. Sorry. I was not shown anything which suggested that either Mr. Costa or Miss Wilkinson reasonably understood anything else by 6th of August 2020. The limited extent of his contribution to the disclaimer is consistent with this, as is his understanding that Miss Wilkinson was to be the final arbiter of any work to be presented to the public. In my view, there was no collaboration. Miss Wilkinson was the sole author of the disclaimer. Mr. Costa did no more than make a suggestion to Miss Wilkinson to improve her work, the suggestion consisting of the addition of words which are commonplace in a disclaimer. Remember, Sergio is citing some of this stuff as a win. Does that sound like so first issue? Who do we think won? Savage Peggy. Savage. What up, Clary? What up? Sorry, I started 10 minutes early. Oh my god, I just realised that. We're at the very start. How you doing? So yeah. So to summarise, case point the first. Brutal savage victory for Dissociated. Brutal savage victory. In my view, there was no collaboration. Miss Wilkinson was the sole author of the disclaimer. Oh yeah, behaviour. What up, Vaz? How you doing? Point the second. Whether Mr. Costa and Miss Wilkinson entered into a contract. Alright, skip past all of this. Blah, 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 blah. So, the consideration of which neither provider nor recipient was apparently aware was given at the time of the contract. By contrast, in the present case, Miss Wilkinson did not commit herself to anything, whether consciously or subconsciously, on 16th of June 2020. The judge goes on to say, signing of a mutual NDA was first floated by Mr. Costa in an email of 20th of April 2020. Had Miss Wilkinson committed herself to signing an NDA on 16th of June without consciously realising that this was what she was doing, there may have been something in this argument, provided also that it was shown that signing an NDA was to her detriment or Mr. Costa's advantage. However, she did not commit herself, knowingly or otherwise. The exchange of NDAs came sometime later in August 2020. Goes on to say here, which I also find interesting, in cross-examination, Miss Wilkinson said that she came to find it difficult to work with Mr. Costa, that working with him became frightening, like walking on eggshells, but this was later. There was no evidence that in June 2020 she thought she would have difficulty in working with Mr. Costa, or indeed that there was any reason to hold such view at the time. And we approach the summary. The pleaded defence is unequivocal as to the principal reason for Mr. Costa's interest as Miss Wilkinson now understands it to have been. Mr. Costa preyed on Miss Wilkinson, then a 23-year-old made vulnerable by her DID condition and by a serious personal incident which she disclosed on Twitter. Mr. Costa sought to ingratiate himself under the guise of being a good Samaritan, but in fact he was intent on a personal relationship, of which intent Miss Wilkinson only gradually became aware before breaking with him in November 2020. There is no need for me to decide whether Miss Wilkinson's view of Mr. Costa's motives, which she maintained at trial, is accurate, and I do not do so. The defendants, so the judge, what she is saying there, the judge is saying she is not providing an opinion on this. So Dissociated has maintained this stance the entire time. Fair play. And the judge is saying, I am not giving an opinion on that. It would not be accurate. I could not accurately do so, and I will not do so. But then the judge goes on to say this. The defendant's alternatives head of consideration is not that on 16th of June 2020 the contract offered Mr. Costa a predatory opportunity to work with Miss Wilkinson. It is that he was being offered and expected to gain professional experience and publicity. I must decide whether this was established on the evidence. Now, I want you to just keep that line there in mind. So what they're saying is, again, they're just really doubling down on the fact, sorry, Faz, they're really doubling down on the fact that they're not weighing on the merit of whether or not Sergio is a creep. Okay? That's basically what the judge is saying. The judge again remarks here, his comments tend to support Miss Wilkinson's concern that he had personal, not professional motives. And here we reach the judge's closing sentiments on this matter. I find that Mr. Costa gained no professional advantage from working with Miss Wilkinson and never expected to. His motives were either altruistic, predatory, or something of both. She didn't need to add that part. That's just to put the ideas into your head. In my view, Mr. Costa received no consideration, thus there was no contract on 16th of June 2020. Now, because of this is one of Sergio's wins, okay? This is a win for Sergio. That's it. That's the closing statement there. That's Sergio's win. But do you see how there's a whole load done previously to keep bringing up the fact predatory? The whole thing is basically pointing out what a fucking creep he is. But legally speaking, there was no contract between them, so Chloe's like counterclaim point here failed. This is one of his wins, guys. One of his wins is the judge speculating on whether or not. One of his wins is the judge saying 3 times that they're not going to speculate on whether or not Sergio is predatory. That's a win. Having the judge bring up the fact that you might be predatory, but she's not there to speculate on it multiple times. Does that sound like a win? Or does that sound like, oh, this person legally wins, but I'm going to burn the shit out of them because I'm a judge? So what this has to do with Vaz is a content creator called Sosa did, who interestingly struck my own channel several times, but then had their content struck by a jealous, scorned, bitter wannabe lover, somebody who failed to get with her, that thought they could get with her, and tried to do the nice guy creepy tactic of being like, I'll be your friend, I'll work for you, whilst being in love with her. And then she realizes she's in love with him and tells him to fuck off, and he abuses his login details to her YouTube account to delete, just effectively destroy all of her content. And again, I don't like the Sosa did, but he destroyed like more than 100 videos from 2 years worth of her history, like overnight. She's a 1 million plus creator on YouTube. Psycho shit. I don't know, Tay, because there weren't 11 points. There are 7 points, aren't there? I know. It's hilarious, right? He's making shit up. Not 10 years older. He's 20 years older. He's 10 years older than me, Angie. He's in his late 40s. When I say he's double her age, she's 25, 24, 25. He's like 48, 50. He's like double her age. 10 years, is a lot, especially for her age, but it's worse. It's worse. And he's wealthy. He's clearly wealthy because he's not having to crowdfund to fight his side of this shit, and we know how much it's costing Associated, so yeah, just humans being crappy, eh? Yeah, Serge is a creep. But yeah, I just find it very interesting that the judge, when awarding Sergio a victory, spends most of it talking about how they can't talk about him being a predator. That's bad news for her. I'm going to discuss that later, Clary. We'll discuss that later, okay? I don't think whoever did that, that is very worrying. Um, Anything over 2 grand gets investigated. That much money, Sergio would be within his legal rights to say he needs to be at the trial and call upon him as a witness and stuff to find out why they're donating so much and things. You can't like anything over 2 grand and things get fiddly. I bet she'll be freaking the fuck out about that. That would Associated has gotten themselves a millionaire sugar daddy. You know, but I don't know. That it almost made me worried for their case. Seeing that genuinely, it's like odd. Right. The implied terms. Point number 3. Since there was no contract, there were no terms, express or implied. But I will consider the arguments on implied terms developed in some detail. Okay? But just keep the very first thing said there in mind. We get to the alleged implied terms. This is so Associated. Remember, it said that there were some implied terms of the contract which we've already found didn't exist. The judge has already said the contract doesn't exist. So Associated's point of implied terms here. You get where this is going to go, right? This is one of Sergio's wins. Just a bit of a nothing burger. None of the joint works have been created by 16th of June 2020. To my mind, they are of no assistance. They are of no assistance in assessing the existence of implied terms because they cannot have been in the contemplation of either Mr. Costa or Miss Wilkinson on that date. It seems to me that Mr. Costa's email of 16th of June provides the best guide to what he and Miss Wilkinson contemplated on that day. Miss Wilkinson was to continue to create content, i.e. material to be used on the Associated channel, and Mr. Costa was offering to help with research, planning, writing, keeping tabs on things, etc. He had earlier said that he would not charge for his help. He had implied that in time he may withdraw. However, it is clear from Miss Wilkinson's evidence that notions of what Mr. Costa would do were vague on 16th of June 2020. Let's get some there. And to summarise, having looked at some legal precedent as well from Sir Thomas Bingham, there was no need for Mr. Costa to grant a licence to allow Miss Wilkinson to follow his advice or to use his research in the form contemplated on 16th of June 2020. Had there been a contract, it would not have contained the implied terms alleged by the defendants. So that's one of Sergio's witnesses. That's Chloe who implied certain terms. It's Associated who implied certain terms in the contract. Well, the contract doesn't exist, and even if it had existed, those implied terms wouldn't have made sense. Huge victory for Sergio. It's effectively just a good opportunity for the judge to have a bit of a discussion on this matter to help explain things for the future. This is the judge actually setting precedent here. This is fantastic. This is precedent setting language going on all over the place here. It's fantastic. That protects so many of us in greater ways than we actually realise. It's really cool. The judge has effectively just passed a ruling there on how contract law in terms of certain parts of digital content and stuff and certain written agreements work in how some can and can't set contracts. It's really fantastic, this. The bare license granted by Miss Costa to Miss Wilkinson. This bit's, I think his one other win. Um, no, this isn't one of his wins. That's right. This is one of his big losses. Yeah, of course. So what this is about, what this section is about, is was yeah, the law and a reasonable notice period. Um, so this is about whether or not the manner with which Sergio revoked his authorized works, his licensed materials, the way in which he revoked them, was that reasonable? And should there have been a notice period? So, what this is about is the strikes, the over 100 strikes on her channel or whatever, or content removals on her channel that he did. The way he did those, should he have legally had to inform her? Should there have been a reasonable notice period? He argues that the removing of the content was his delivering of a notice period of severance of work. We'll get to their argument. So the judge explains the precedent, explains the law, how it all works, and we get to the notice period in this case. And what matters. So, one, the effect on the defendant's business if the notice period were too short. Ms. Wilkinson said in cross-examination that there would have been a loss of trust amongst those viewing her channel if her videos had all been suddenly taken down. I accept that evidence. There's a few other points that matter. Mr. Costa's point. So, and then we get, right, here's the important part. The defendant submitted that a reasonable notice period was 12 months. Mr. Costa said 30 days. So Sergio was arguing that he, yes, probably should have given 30 days notice. Chloe was arguing 12 months would have been reasonable. Here we get the reasons why. And then here we get the judge's opinion. I think a strong factor in the assessment is that there was neither evidence nor even an unsupported assertion made on behalf of Mr. Costa that he suffered any harm at all while the joint works remained on the defendant's channel. Nor was there evidence or assertion that he would profit from their removal. His reasonable self would have wished there to be no concern caused to the many viewers of the channel. I have no doubt that in the real world, Mr. Costa would have been uncompromising. But in the hypothetical world of Mr. Costa acting reasonably, I think he would have taken a very relaxed attitude to the required act of deletion and replacement. I also assume that during the relevant period, Miss Wilkinson would have had wished to spend time creating wholly new and additional material, as well as otherwise running the channel. Taking all of this into account, I have reached the conclusion that the parties would have agreed a period of twice the assumed 4-month period for the first making of the infringing material, i.e. 8 months, expiring on 23rd July 2021. Ergo, the judge saying 8 months is, Sergio should have said, right, I don't want to work with you anymore. You have 8 months, and then those videos are gone. 8 months. That's a big win. Also shit like this language here. In the hypothetical world of Mr. Costa acting reasonably. In the hypothetical world of Mr. Costa acting reasonably. In the imaginary fantasy world where Mr. Costa doesn't act like a dickhead, like a deranged lunatic. Where he acts reasonable. That's a bun. So the judge does find that Mr. Costa's rights in the joint works have been infringed. But although there was no evidence that Mr. Costa suffered loss because of the infringement, Mr. Costa is not precluded from either filing evidence in an inquiry or claiming nominal damages or seeking an account. If an inquiry or account is sought, the court will have to be satisfied in due course that the scale of compensation likely to be awarded is proportionate to the time of the court that would be taken up in assessing what the sum is. So, what this is saying is basically Sergio has to prove that after promising that he didn't want to make any money from any of this, that he's lost money from Dissociated keeping that he would have lost money from Dissociated keeping the videos up. So he wins, but he can't do anything with this win. It's another nothing burger because no court would accept that there's an amount of money that he's owed when he said that he didn't want any money. So it's still not a win for him. Then we get to something on estoppel. At trial, Mr. Elias raised the argument that Mr. Costa was estopped from terminating the license. This was not properly pleaded. They go on to say, this will not do. Paragraph 9, blah, 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 states, as it is, I will not consider an estop. So that's a Sergio loss. Counterclaim. Counterclaim for breach of contract is dismissed because there was no contract. There remains the counterclaim for causing loss by unlawful means. So, counterclaim for breach of contract is dismissed. Doesn't matter. It's gone. There was no contract to be breached. It's hilarious. However, the counterclaim for causing loss by unlawful means. And here we get to something that is not a nothing burger. And here we get to why Chloe was so giddy yesterday. Because counterclaim for causing loss by unlawful means. Ergo, does Chloe's counterclaim that Sergio has caused her financial loss by unlawful means, does that hold ground? This whole bit is kind of interesting, but I'm just gonna speedy through it. The important part is one of the important parts is where they're so here the judge is explaining how you decide whether something is unlawful interference. Okay, and it's made up of 4 main elements that are explained here. Acts by the defendant against the third party in which the claimant has an economic interest, which are actionable in law by the third party, where such acts affect the freedom of the third party to deal with the claimant, and where there is an intention on the part of the defendant thereby to cause loss to the claimant. Okay? And what do we know from various messages we've seen that we know got submitted as evidence about whether or not Sergio wanted to cause dissociated harm, financial harm and loss? We know he did. Going back to the first and second elements, the takedown requests were to YouTube, an organisation in which the defendants have an economic interests in that it hosts the channel through which the first defendant runs its business. The issue is whether the requests included acts against YouTube in the sense of being actionable by YouTube. The defendants alleged that YouTube had a cause of action against Mr. Costa for deceit. And she goes on to say, she pauses just before making her decision. She pauses to say, I pause here to make a pedantic point. A work of co-authorship is a work produced by the collaboration of the author of a musical work and the author of a literary work, where the two works, music and lyrics, are created in order to be used together. Blah, 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 blah. Sergio is trying to claim co-authorship. You can't have co-authorship because it's something that exists for the collaboration of musical works and literary works. the judge just burned Sergio and the legal team to say Mr. Costa should be taken to have made representations of being a joint author, not a co-author. Fucking pleb. Literally, the judge just being a pedant to insult Mr. Costa and his legal team. Beautiful. Actually beautiful. I found that Mr. Costa was not a joint author of the disclaimer. The representation that he were false. After 13th of March 2021, the representation that the defendants were using the disclaimer was false. The representation that it was being used without his permission was also false from that date. It makes no difference that on my findings above, such use was licensed until 23rd July 2021. And there's a little discussion of knowledge or recklessness. I take the view that the defendants are right about this. The evidence makes it likely not that Mr. Costa's representation of 22nd February 2021 that the defendants were using the disclaimer without his permission was maintained at least. No, that one's. Oh, yeah. Oh, no, this is the interesting part. This position was maintained even though Mr. Costa knew that it was false. This is the judge saying that Mr. Costa has been lying in the previous trials. Let me, I shouldn't have skipped over this. Let me read this fully. I take the view that the defendants are right about this, the defendants being Chloe. The evidence makes it more likely than not that Mr. Costa's representation of the 22nd of February that the defendants were using the disclaimer without his permission was maintained at least until 25th of June 2021, and from 13th of March 2021 was maintained even though Mr. Costa knew that it was false. He lied in court. In this judge's opinion. That's as close as a judge can get to saying somebody lied in court without accusing them of perjury. The evidence makes it more likely than not. She's not outright calling him a liar. She's just saying the evidence makes it more likely that he's lying than that he's fucking stupid. She's giving him that branch, that olive branch, that maybe he's just fucking stupid. You know, sorry. There's that opportunity there for him. But that is legalese for you perjured yourself in court. And I'm not going to say it outright, but I don't like you. Do you remember I said there was some like fiery legalese? This is, I don't know how he thinks he's won anything here. This is humiliating. He is being called over and over a Weasley little liar by a judge. And a predatory one. Like, wow. If I was dissociated, I would be genuinely giddy. Because as this is going to go on to say, this gives her all the ammunition in the world that she could have ever wanted to countersue for unlawful interference, which she is going to do. She's very said she's going to. And now she wins that. And she wins that. Sadly, I think she might be able to make 50 grand or so out of it, to be fair. I don't know, but she wins. It's no longer a case of he wins. It's she wins. Big. He's legally, he is legally speaking a predatory Weasley little liar. But not legally speaking, because the judge isn't saying that. The judge isn't opining on those things. Just keeps bringing them up. By the time of the trial, Mr. Costa may have come to believe that all that mattered was whether his representation was true on the 22nd of February 21. I do not accept that this is what he was thinking at the end of June 21. He knew that YouTube had continued to rely on his representation. He had not corrected it, and he was apparently content with the result. I do not believe that at this time he gave any thought to whether what he had represented on 22nd of February was right or wrong, strictly as of that date. He asked for advice on 13th of March 2021. Asking for advice is not the same thing as informing YouTube that, contrary to what he had said earlier, the defendants were no longer using the disclaimer. He allowed YouTube to continue to believe that the disclaimer was being used, and can only have done so because he intended that YouTube should act on that belief. I find that Mr. Costa intended, after 13th of March 21, that YouTube should continue to rely on his representation that the defendants were using the disclaimer without his permission. It is legally found that that Sergio Costa lied to YouTube and abused the system to harm Dissociated's business. Continues, it follows from the foregoing that YouTube relied on Mr. Costa's misrepresentation. Conclusion on deceit. Mr. Costa's representation to YouTube that he was joint author of the disclaimer was false, but he honestly believed it to be true and was not reckless as to its truth. The representation that the disclaimer was being used without Mr. Costa's permission was false after 13th of March. Mr. Costa knew it to be false. YouTube relied on the representation after that date, and Mr. Costa intended it so. And to finish this section, or not almost. The reasons given above, I have no doubt that Mr. Costa intended all his representations, including that concerning the defendant's continuing use of the disclaimer, to cause YouTube to take action. In cross-examination, he said that in his takedown requests relating to the disclaimer, he had stated that it appeared in the description. This appears to be true. The implied point, as I understand it, was that he only expected the descriptions to be removed or edited, not the videos taken down. Mr. Costa's first takedown requests were made on 22nd February 2021, in which he reported 81 URLs to which his complaints related. I should read all of this, sorry. YouTube's confirmation contained an entry for each URL. Those relating to the disclaimer included this. Where does the content appear? Description. However, at the head of each entry, there was this. URL of allegedly infringing video to be removed. So, ergo, Sergio had to know. The judge is saying Sergio had to know that the video was going to be removed, not just description. Given that heading, I think that Mr. Costa must have understood that where his complaint was about the disclaimer at a stated URL, the action taken by YouTube would be the removal of the video at that URL. Moreover, YouTube had separate complaint procedures for video and non-video content. He could have filed a non-video complaint, which would seem to have been more appropriate and would have been less likely to risk the removal of the defendant's videos. He was asked about this in cross-examination and gave no satisfactory answer. And it gets a little bit spicier, and we're almost done. It gets even spicier. Oh. So, in regards to the takedown requests still, it was submitted on behalf of Mr. Costa that his acts leading to takedown requests were motivated not by a desire to inflict loss on the defendants, but only to protect his intellectual property rights and to prevent his rights being used in a way of which he did not approve. It was said that Mr. Costa's position was summed up in this part of paragraph 65 of his witness statement. Okay? That's what did Sergio say in this part of his witness statement. Since March 2020, I had watched the second defendant amass a large audience comprised mostly of vulnerable people, and for me, helping her was always about doing some good for the world. However, at that point I realised that I might have been an unwitting party to fraud. I knew that I would never find peace knowing that my work was being used irresponsibly or in a way that could cause harm to others. That was not what I signed up for, and with what I now knew, I would have never offered to help the second defendant or let her use my work under any circumstances. These are strong words, Miss Wilkinson's alleged fraud appears to be a reference back to what Mr. Costa had said earlier in his statement at paragraph 56, where he talks about the money, something that I consider to be fraud. I was therefore worried with the defendant's work, blah, blah, blah. I did not think the second defendant's mental health was stable enough to return to YouTube and asked her to wait until January 2021. I felt wronged by the defendants after having dedicated so much of myself to Dissociated and been promised a contract only to be discarded under what I considered to be false pretenses. Mr. Costa was asked in cross-examination why he had not more fully explained his allegation of fraud. He said that this case was not about fraud, so he had not said anything further about it. It was not put to Miss Wilkinson that she had lied to patrons or anyone else about her rent. I take her patrons to be viewers of a channel, and there was no evidence at all to support this allegation. I find that the allegation of fraud has no basis in truth. So the last reason he was hoping for a contract and been discarded is the part that rings true for her. These parts largely ring true about him being bitter. I think it is likely that there was a further reason. Mr. Costa had been very keen to work with Miss Wilkinson, and she had rebuffed him. I can easily believe that through the cumulative effect of these, Mr. Costa became angry. The judge could see it. The judge sees it. Rebuffed meaning just rejected. Mr. Costa had been very keen to work with Miss Wilkinson, and she had then rebuffed him, emotionally rebuffed him, his sexual advances. I can easily believe that through the cumulative effect of these things, Mr. Costa became angry. I hope it is. Yeah, she's a woman. I remember originally thinking that the fact that there was that she had a woman as a judge gave her that was the one sliver of hope, and I think it's proven true. I still think that Sergio would have won had this been an old white stuffy judge or something. I genuinely do. Actually got a woman who looked into this and saw. Ultimately, if you're a woman and you're a judge, you've probably dealt with a lot of sexism in your life. I mean, how many times when they've been training as a lawyer and working their way up, will have somebody been like, oh, clerk, oh, secretary, and they're like, I'm a lawyer, I'm a judge, you know, I'm a fucking judge. You know it'll have happened. And those messages from him where he gets angry at her and says, if I was a lesbian, if only I was a lesbian, you'd be with me, or some shit. I can't remember it. It's pretty much that. I think a lot of women have received a message like that in their life. I think a lot of women have received a very similar angry, nice guy message from somebody that they genuinely thought was a friend. Or maybe sometimes it's that, oh, if only I was 6 foot. Oh, if only I was that guy. Oh, if only I was lesbian. Oh, you know. Like, wow, dude. Wow. And the judge saw it. And I love it. Mr. Costa's reaction had been more confined to efforts to restrain the defendant from exploiting the joint works in the disclaimer. The fourth element of the tort would not have been satisfied. Restraining the defendant in this way would foreseeably have caused harm to the defendants, but harm would not have been a desired end in and of itself. However, I have found that Mr. Costa intended that his takedown requests, based on the disclaimer, should result in the defendant's videos being taken down, even though he knew that the disclaimer was only contained in the descriptions. I think that the only fair inference I can draw is that Mr. Costa did this, achieved in part by his false representations that the defendants were using the disclaimer because he wanted to cause harm to the defendants. Harm generated by videos vanishing in large numbers from the channel. The fourth element of the tort is satisfied. The counterclaim succeeds. So on the most important aspect, yeah, Sergio had 3 wins. 3 out of the 7 points Sergio won, maybe. One of them, they both lost. 2 of them, they both lost. So yeah, technically in numbers, Sergio wins 3, Chloe wins 2, and 2 of them, neither one. So technically on numbers, Sergio wins. But Sergio isn't allowed to do anything with his wins, whereas he has been found guilty of a criminal action now. This isn't just a civil action anymore. I believe because of the statute of limitations on this sort of thing, it will still just end up getting done in civil court, but that's a criminal action that she's found him guilty of. And now it goes to quantum of loss and the counterclaim, ergo, how much money? Yeah, good for her as well. I fucking agree completely. It's ridiculous. As I said at the start, any issue I've had with Associated has been not one related to, like, they should have never struck me, but then I got that stuff sorted and resolved and it was fine. Sergio shouldn't have then gone apeshit realizing that he could abuse something like that. It was sick. Sick. So the main point here is this is a dispute between 2 individuals, not between well-financed corporations. In my view, there should be a set-off before money changes hands in one direction or the other. If Mr. Costa does not seek an inquiry or account, I will assess the defendant's claims on the papers following the further brief submissions. But he will be doing that, but it won't go far. Like, he's not going to get that stuff sorted. No. Overall conclusion. Mr. Costa was not a joint author of the disclaimer. There was no contract between Mr. Costa and Miss Wilkinson. Had the contract existed, it would not have contained the implied terms alleged by Miss Wilkinson. The defendant committed acts of infringement of Mr. Costa's rights in the copyright and the joint works after the end of the bare license granted by Mr. Costa. The defendant's counterclaim for a breach of contract is dismissed. The counterclaim that Mr. Costa caused the defendant's loss by unlawful means succeeds. Assessment of loss to the defendants is adjourned to be heard at the same time as Mr. Costa's inquiry or account, or if there is none, to a decision on the papers. So, yeah, you might read that and it seems like Mr. Costa won more things there, but he can't do anything with the shit he won. And the counterclaim that Mr. Costa caused the defendant's loss by unlawful means succeeds. Ergo, she's won, and now they just have to decide how much he owes. It's not a case of did Sergio try to destroy Dissociated's business? That's not a question anymore. It's Sergio tried to destroy Dissociated's business. How much money does he owe her? That's what he now has to fight the next time in court. That's going to be a lot more fun for her and her lawyers. You know what I mean? That's the bit the lawyers enjoy. Time to make arguments as to how much money you owe us. Interesting times. Yeah. Earnings from 2021, but Larry, it's also that the year before that they were 50k, the year before that 53k, year after that over 100k. If her lawyers can make the argument that her growth would have doubled again, which they easily could. Easily. Like, he fucked himself. So yeah, congratulations to Associated. Genuinely, it's kind of hilarious. It's actually kind of hilarious. Um, some parts of this, you fucking won hard. There's winning, and then there's destroying the enemy. It's kind of funny. Ah, thank you so much for joining me on that, loungers. Peace. Don't worry, I'm not going anywhere. Be that.